Thank you everyone for joining us today. My name is Diana Padierna and I am the Executive Director at the Landlord Self-Help Center. We are excited to resume our Landlord Lunch and Learn series. So I'll just go through some housekeeping reminders before we start. We are recording this webinar and it will be available on the Landlord Self-Help Center's website in case that you would like to rewatch. Also, the Q&A is open for your questions, which will be addressed during our Q&A period at the end of the presentation. Our presenters will be answering only questions pertaining to this webinar. If you have any questions about your situation in particular, please contact our office. Okay, so let's begin.
Thank you, Diana. Hello and welcome to the Landlord Self-Help Center's Lunch and Learn session. The Landlord Self-Help Center is a community legal clinic funded by Legal Aid Ontario. We currently have 5 licensed paralegals working at the Landlord Self-Help Center. The Landlord Self-Help Center was founded in 1975 and incorporated in 1977. We have a province-wide mandate to support the small-scale landlord community. Approximately 80% of the Landlord Self-Help Center's resources are dedicated to direct client services. My name is Ashley, and I'm being joined by my colleague Catherine today to give this Lunch and Learn series to you. We are both community legal workers and licensed paralegals. This Landlord Lunch and Learn session will focus on tenant applications from a landlord's perspective. The information offered in this presentation is intended as general information. It is not legal advice. At the Landlord Self-Help Center, we acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13, with the Mississaugas of the Credit and the Williams Treaties signed with multiple Mississaugas and Chippewa bands. As a community legal clinic funded by Legal Aid Ontario with a province-wide mandate, we acknowledge that there are 46 treaties and other agreements that cover the territory now called Ontario, and we make this acknowledgement in support of the necessary work of reconciliation. The Residential Tenancies Act. The Residential Tenancies Act is Ontario legislation that governs residential tenancies and matters related to renting in Ontario. It is commonly referred to as the RTA. The RTA was created in 2006. It establishes laws for landlord and tenant obligations, rent increases, grounds for termination of tenancies. Section 29 to 32 of the Residential Tenancies Act discusses tenant applications.
What is a tenant application? The Residential Tenancies Act gives authority to the Landlord-Tenant Board to resolve disputes between landlords and tenants. As such, a tenant application is similar to any other lawsuit, but is brought forth exclusively by tenants to be heard in front of an adjudicator at the Landlord-Tenant Board. Both current tenants and former tenants up to 1 year after their tenancy ended can file an application with the Landlord-Tenant Board when they are having a dispute with their landlord or when they feel the landlord has done something wrong or violated the rules and/or obligations under the Residential Tenancies Act. Tenants who file tenant applications are often seeking some form of monetary compensation, an end to a behavior, or an order issuing the landlord to fix something. It is important to note that there's a 1-year limitation period. It's extended to 2 years if the former tenant received an N13 notice, and that notice is the reason for their application. To provide some perspective about how common tenant applications are, the Landlord-Tenant Board received 8,455 tenant applications versus 64,450 landlord applications, according to the Tribunal's Ontario 2000 2023 business report. Unlike landlord applications, where a notice must first be served to the tenant, tenants are not required to provide their landlord with notice before they file an application. Once the tenant files an application, the Landlord-Tenant Board will notify the landlord and tenant by email or mail with a notice of hearing, which will provide the date, time, and Zoom link of the hearing. This email will also contain a file number and a link to the Landlord-Tenant Board's portal and a PIN. Landlords can create an account with the Landlord-Tenant Board portal and log into it. They can then use the PIN to link the file to their portal account and review the application. If a tenant does not have the landlord's email address or did not include it in the application, the Landlord-Tenant Board will only send the notice of hearing package to the landlord by regular mail. What are reasons for an application? Each tenant application has prescribed reasons for the application. It is important for landlords to review the application to determine which reasons the tenant had selected, and this will become the allegation that the landlord will have to defend. Each reason is always based on the allegation that the landlord did something in violation of the Residential Tenancies Act. Ashley will discuss the different reasons for each specific application later in this presentation. Remedies for an application. Each application has prescribed remedies or requests of what the tenant is seeking. It is important for landlords to review the application to determine which remedy the tenant is seeking. As discussed at the beginning of this presentation, tenants are often seeking some form of monetary compensation, an end to a behavior, or an order issuing the landlord to fix something. Some examples of monetary compensation that can be rewarded to tenants are reimbursement if the landlord collected an illegal deposit or illegal rent increase, a rent abatement, which is normally calculated as a percentage off of the tenant's rent, reimbursement for out-of-pocket expenses that the tenant used for perhaps fixing repairs or moving costs, the difference in rent when the former tenant was forced to move out due to the landlord's actions and is incurring a higher monthly rental amount. This would only be rewarded for a maximum of up to 12 months. In severe circumstances, the Landlord-Tenant Board also has the ability to charge the landlord with an administrative fine or reward punitive damages to the tenant. It is important to note the most the Landlord-Tenant Board has the authority to order is the same amount as the jurisdiction of the small claims court, which is currently $35,000. The Rental Housing Enforcement Unit also has the ability to issue fines to landlords who violate the Residential Tenancies Act. Currently, those fines can be up to $50,000 for an individual or up to $250,000 for a corporation.
Today, we're going to go through the most common tenant applications. This presentation does not cover every single tenant application. However, we will go through the most common. We're going to start with the T1 application. A tenant may file a T1 application for a rebate of the money the landlord owes. The tenant may file this application for the following reasons. Reason 1, my landlord charged me an illegal rent, which I have paid. Reason 2, I paid an illegal charge to my landlord's agent, or the superintendent. Reason 3, the landlord did not use my last month's rent deposit to pay for the last rental period of the tenancy and did not return the deposit to me. Reason 4, I entered into a tenancy agreement with the landlord, but the landlord did not allow me to move into the rental unit and did not return the money I paid as a deposit. Reason 5, the landlord owes me interest on the last month's rent deposit. Reason 6, The landlord gave me one of the following notices to end my tenancy and did not pay me compensation by the termination date on the notice, N12 or N13. Reason 7, the landlord sold my personal property and did not pay me the proceeds from the sale. Reason 8, the landlord did not give me the required notice telling me that there was an order prohibiting a rent increase affecting my rental unit. The remedies a tenant may seek on a T1 application include an order seeking the monies collected by the landlord. T2, a tenant may file a T2 application for the following reasons. Reason 1, the landlord entered my unit illegally. Reason 2, change the locks or the locking system to my rental unit or building without giving me replacement keys. Reason 3, substantially interfered with my reasonable enjoyment of the rental unit or complex, or with the reasonable enjoyment of a member of my household. Reason 4, harassed, coerced, obstructed, threatened, or interfered with me. Reason 5, withheld or interfered with my vital services, which are heat from September 1st to June 15th, fuel, electricity, gas, hot or cold water, or care services and meals in my care home. Reason 6, did not give me 72 hours to remove my property from the rental unit or from someplace close to it after the sheriff evicted me. Reason 7, did not give me a written tenancy agreement for my care home unit or gave me an agreement that did not include information about my care services and meals and or the charges we agreed I would pay for them. The remedies a tenant may seek on a T2 application include a rent abatement in order to stop specific activities described by the tenant, a fine from the landlord and tenant board, the landlord and tenant board to end the tenancy, costs to repair or replace property that was damaged, destroyed, or disposed of, a difference in rent for a period of up to 1 year, moving and storage expenses, out-of-pocket expenses, in order to move back into the rental unit in the cases of an illegal lockout, return of belongings, and other remedies as described by the tenant, which may include punitive damages or pain and suffering. T5. A tenant may file a T5 application for the following reasons. Reason 1, the landlord gave me Form N12 notice to end your tenancy, claiming that either the landlord or one of the following people intended to move into the rental unit: a member of the landlord's immediate family, a person who provides or who will provide care services to the landlord, or a member of the landlord's immediate family. Reason 2, the landlord gave me a Form N12 notice to end your tenancy, claiming that either the purchaser or one of the following people intended to move into the rental unit: a member of the purchaser's immediate family, a person who provides or who will provide care services to the purchaser, or a member of the purchaser's family. Reason 3, the landlord gave me a Form N13 to end your tenancy because the landlord wants to demolish the rental unit, repair it, or convert it to another use. Reason 4, the landlord gave me a Form N13 to end your tenancy because the landlord wanted to do repairs or renovations to the rental unit. I gave the landlord notice in writing that I wanted to move back in once the work was done. The landlord did not give me the right to move back into the rental unit when the work was done. The remedies a tenant may seek on a T5 application include a rent abatement, a fine to the landlord and tenant board, the difference in rent for a period of up to 1 year, moving and storage expenses, general compensation, and any other remedies as described by the tenant. T6. A T6 is an application a tenant may apply for maintenance issues. The reason a tenant would file this application is I am applying to the board because the landlord has not repaired or maintained the rental unit or the residential complex, or has not complied with health, safety, housing, or maintenance standards. The remedies a tenant may seek on a T6 application include a rent abatement, costs to repair or replace property damaged, destroyed, or disposed of, out-of-pocket expenses, the cost of repair or replacement work by the tenant, in order to allow the tenants to do the repairs and have the landlord pay for those costs, in order that the landlord must do the repairs, replacement, or other work necessary, in order that the landlord cannot increase the rent until the landlord completes the necessary work, the landlord and tenant board to terminate the tenancy, and any other remedy as described by the tenant.
The hearing. Landlord-tenant board hearings are held virtually via Zoom. Multiple hearings are scheduled for the same Zoom meeting, so you need to be prepared to participate in the hearing for the whole day. It is important to understand that when it is a tenant application, the onus or burden of proof lies with the tenant. As such, they have to successfully plead their allegations on a balance of probabilities. Once it is time for your tenant's application to be heard, the tenant will have the chance to provide evidence, provide verbal testimony, and rely on witnesses to provide their testimony. After the tenant submits their case, the landlord is given the chance to cross-examine the tenant by asking specific questions about the tenant's testimony. Next, the landlord is given the opportunity to produce their evidence, provide their own verbal testimony, and produce their own witnesses. The tenant also has the chance to cross-examine the landlord and any of their witnesses that they bring to the hearing. Both parties present their case to the adjudicator, who is essentially the judge of the landlord-tenant board. Adjudicators are sometimes referred to as member or chair. At many hearings, adjudicators will also ask both parties questions to ensure they have a good and complete understanding of the facts. How do you prepare for the hearing? With tenant applications, the onus or burden of proof falls on the tenant. However, the landlord has the ability to defend the allegations. A landlord should carefully review the application line by line and make sure they understand the specific allegations or remedies the tenant is seeking. This will ensure that they are prepared to adequately defend all of the issues raised. Once there is an understanding of the allegations, landlords can compile the evidence they intend to rely on at the hearing. Landlords can also decide which witnesses they would like to have testify. If someone intends to rely on witness testimony, they should take the time to prepare their witnesses. Both parties are required to provide all of their evidence to both the landlord-tenant board and the other party no later than 7 days before the hearing. It is recommended that your evidence is submitted with a table of contents and each item is easily identifiable. After receiving your tenant's evidence, you should carefully review everything they intend to rely on at the hearing. Some adjudicators will also ask for closing statements or final submissions. It is a good idea to be prepared with a summary of what you would like the adjudicator to order and why. Moving on to evidence. It is important to make sure that any evidence a landlord submits is relevant to the issue at hand. Evidence can be in many different formats and can include things like written correspondence between the landlord and the tenant, for example, screenshots of text messages or emails, photographs, for an example, a time-stamped picture of something after it was repaired, verbal testimony, which can come from the landlord themselves or any witnesses, or something like a receipt or an invoice. For example, if an item was repaired and you have an invoice proving that it had been repaired. It is important to consider that the general rules of evidence apply. For example, if written correspondence was a part of negotiations between the landlord and the tenant for the purposes of resolving the dispute, This would be considered privilege and should not be included. Also, you should not submit evidence if it was obtained illegally. For an example, video footage that was obtained while filming the tenant without their knowledge or reasonable understanding. After the hearing, you will receive what's called the order. The adjudicator will be the person who decides the outcome of your case in writing, and that essentially is the order. In most cases, the adjudicator will reserve their decision. This means at the end of the hearing, the landlord or the tenant will not know the outcome and they have to wait to receive the order. The order will be provided to the landlord the same way they received the notice of hearing. It will outline the remedies, if any, that are granted to the tenant. If the tenant was successful with their application, the order could outline how much money is owed to the tenant and when the landlord has to pay the tenant by, or a list of maintenance tasks the landlord is required to fix and how long they will have to fix it. It may include other remedies that the tenant had selected if they're successful with that request. Currently, the Landlord-Tenant Board is taking up to 60 days to release their orders. Once you get the order, there is the opportunity to review it by either party. If either party does not agree with the decision that is put in the order because it contains an error of fact, error of law, or because someone was unable to participate, they can apply to the Landlord-Tenant Board with a request to review an order within 30 days of the date of the order. Neither the landlord or the tenant is able to review or appeal the order just because they don't agree with the decision. In some cases, there may be an error, like a clerical error or a spelling mistake, or an error of calculation. In this case, you would use the request to amend an order form, which you also have 30 days to file.
Tips: review the application. Review the application that has been filed in full. Understand the claims and be prepared to defend all of the allegations listed. It is very important for a landlord to know which application has been filed against them and to understand the allegations and remedies sought within that application. Understanding your obligations. Having a full understanding of your obligations as a landlord under the Residential Tenancies Act, such as collecting a deposit, what constitutes bad faith, or your requirement to keep the rental unit in good state of repair, will ensure you can lower the chances of a tenant bringing an application against you. You should fully understand your rights and obligations. If you have any questions about obligations, you should seek independent legal advice from a lawyer or paralegal. Mediation. You can voluntarily attend mediation to discuss issues and possible remedies with your tenant. A mediated agreement is a private and confidential agreement between you and the tenant. The Landlord and Tenant Board will provide mediators on certain blocks. If you wish to mediate, and the tenant also wishes to mediate, you may do so. Resources. The Landlord Self-Help Center has a website. We can be found at www.landlordselfhelp.com. We have an array of resources to assist you in understanding your rights and obligations as a landlord. We have fact sheets, frequently asked questions, quarterly newsletter, and learning modules. All of these may be found on our website. You can also find us on Facebook at www.facebook.com/landlordselfhelp. We also have a YouTube with educational videos that you can watch, and you can find us there at Landlord Self-Help Center 7429, or you can just search us on YouTube, Landlord Self-Help, and our account should come up. The Landlord and Tenant Board is also another great resource. You can go to tribunalsontario.ca. They have information about renting in Ontario. They have practice directions, specifically the one on evidence. would be handy in situations where you need to supply evidence before the board. They also have interpretation guidelines. Rule 19 specifically discusses disclosure and evidence. If you are looking for a lawyer or paralegal to represent you at a landlord and tenant board hearing, you may use the Law Society Referral Service. You can find them at www.findlegalhelp.ca. You would punch in what you're looking for, and you will find a lawyer or paralegal match who will give you a 30-minute free consultation.
That concludes our first webinar for the Landlord Lunch and Learn series. There will be 2 more this season. The next one is scheduled for September 18th at 1 p.m. where we'll discuss self-representation at the Landlord Tenant Board hearing. In November on the 13th at 1 p.m., we'll have another one about filing with the sheriff for eviction and what to expect when you have to do that. Now we will get started with our question and answer period.
Thank you very much, Ashley and Catherine, for the very informative session today. And just a reminder to everyone, we have our Q&A questions feature enabled. So if you have a question, please send it through the Q&A. I'm going to start reading out the previously received questions. All registrants had an opportunity to send any questions they had prior to the webinar. So we're going to go through those questions first. So the first question received reads as follows. I am not very good with computers and technology in general. Do I have to participate in the hearing through Zoom? Ashley, can you please answer that question?
Yes. So you do not have to participate in the hearing through Zoom. The Landlord and Tenant Board will send out a notice of hearing. On this notice of hearing, it includes the Zoom link, but it also includes a telephone number. You may call into the telephone number and use the PIN provided on the notice of hearing if you are unable to use Zoom. In the event that you have a serious need for accommodation, you may also use a request for accommodation form to request a different format of hearing. The Landlord and Tenant Board would review your request for accommodation and make a decision on whether to grant that or not.
Thank you so much, Ashley. Another question that we received pertaining to this webinar reads as follows. What are some of the reasons a landlord can be fined for based on a tenant application? Catherine, can you please answer that question?
Yes. First off, it's important to note that there's a difference of fines that you would receive through the Rental Housing Enforcement Unit or administrative fines that you would receive through the Landlord Tenant Board. As Ashley discussed while she was going through the different applications, one of the remedies some of the applications lead itself to is fines. So first, your tenant has to request in their application that a fine be paid. From what we see, typically the Landlord Tenant Board doesn't issue fines very often. It has to be very severe circumstances, like illegally locking out a tenant, or if there's been a pattern of bad behavior, like issuing N12s multiple times under bad faith circumstances.
Thank you so much. As mentioned before, one of the remedies that a tenant can ask, it's a rent abatement. And one of the clients that sent a question, he wants to know, what does a rent abatement mean? Ashley, can you please answer the question?
Yes. So a rent abatement is typically a percentage of the monthly rent a tenant pays. The tenant can request a rent abatement for the amount of months that they have been dealing with an issue. And again, it's typically a percentage of their full monthly rent based on how severe the issue is.
Thank you so much. I think we have somebody that raised their hand, but I see that they also typed the question in the Q&A feature. So once we answer all the questions previously received, we're going to go through the Q&A feature. So if you have any questions pertaining to this webinar, this is the time that you can start typing your question. Somebody else asked, what if I can participate on the day they schedule my hearing? And is it necessary to hire a paralegal? Catherine, can you please answer that question?
Yeah. If you're not able to participate on the day of the hearing, there is a request to reschedule form. You would have to receive your tenant's consent in writing that they're agreeable to reschedule the hearing, in which case your rescheduling would be granted. If the tenants don't consent, the likelihood that the landlord tenant board is going to grant the rescheduling is quite slim. If that's the case, you could have somebody, rather a paralegal or even an agent on your behalf, attend the hearing for you. You can then, on the day of, request an adjournment, but we always recommend to be prepared to proceed with the hearing in the event that you're denied your request to adjourn. For hiring paralegals in general, the landlord tenant board is, designed to be accessible to self-represented parties. However, if your application or your tenant's application is quite complex, it may be good for you to hire representation and have somebody who, is an expert in that area of law be there for you as support.
Thank you so much, Catherine. So as we have diverse landlords with different backgrounds, one of the landlords is wondering if the landlord and tenant board provides interpreters for hearings. Ashley, can you please answer that question?
Yes. So generally, no. However, a landlord may submit a request for accommodation seeking an interpreter. The landlord and tenant board will then generally send out a financial qualification guide. And if a person meets their financial qualifications, the landlord and tenant board may provide an interpreter. This is typically done for languages outside of English or French, and it would depend on financial qualifications. Landlords should be prepared to bring an interpreter with them to a hearing in the event that this is not granted.
As well, American Sign Language interpreters, right, are provided by the landlord and tenant board?
Yes, you can definitely put in the request for accommodation, and the landlord tenant board responds to that request with yes or no based on if they can grant that or not. But it is an accommodation and they do grant those.
Thank you so much, Ashley. Another question received reads as follows. The application my tenant filed has clerical errors or is incomplete. Will it be dismissed? Catherine, can you please answer that question?
Yeah, it really depends on the type and the severity of the clerical error. Most common adjudicators will adjourn the hearing and allow the tenant the ability to amend whatever error was on the application. Minor errors like, misspelling names or that sort of thing, typically you can get addressed on the spot and the hearing will continue.
Thank you so much. Okay, another question says, my tenant no longer lives in the rental unit. Will the application they filed with the landlord and tenant board against me proceed? Ashley, can you please answer that question?
Yes. So the application will likely still proceed. A tenant and or former tenant has up to 12 months from the date of incident to file an application with the landlord tenant board. Just because they have moved out does not mean the application will not succeed. They are still able to bring that and proceed as long as it's within the time limitation.
Thank you so much. Another question reads as follows. Do I have to respond to a tenant application? How long do I have to do so? Catherine, can you please answer?
Yeah, I actually get this question a lot of people calling in. Unlike other legal proceedings, where there be a statement of claim and whoever that's filed against has to file a defense, that's not the case for the landlord-tenant board. Once you receive the application, there is no defense or written response required. Essentially, your next step would be reviewing the application, compiling your evidence, and preparing for the hearing. So you don't have to submit anything to either the landlord-tenant board or the tenant until it's time to disclose evidence, which has a timeline of 7 days before the hearing.
Thank you so much, Catherine. Somebody else was asking, can a tenant file multiple applications against me? Ashley, can you answer that question, please?
Yes, a tenant may file multiple applications against a landlord. The most common combination that we see is the T6 tenant rights application and the T6 maintenance application. However, if a tenant has differing reasons to file an application, they may file each relevant application against a landlord.
Thank you so much. Somebody else was asking, can the tenant ask to join their application with the landlord's ongoing eviction application? Catherine, can you please answer that?
Yes. So when it's actually an L1, L9, or L10 application for rent arrears, under Section 82, the tenant doesn't have to file their own application. They can bring forth issues that they would be able to bring in their own application. If they have decided to file their own application, well, there's an application that you have filed against them. Rather yourself or your tenant can request the landlord-tenant board merge the applications. It's probably, if there's money owing from your tenant, it would be something good to do in the event of offsets.
Okay, thank you so much for that answer. We're almost done with the previously received questions. Another question reads as follows. My tenant told me she filed an application against me, but she did not give me notice. How would I know that what she filed against me? Ashley, can you please answer that question?
Yes, so when a tenant files an application, the landlord and tenant board typically sends out a portal PIN message. This would advise that a tenant has filed an application against a landlord and provide that landlord with the PIN that they can then connect to the tribunal's Ontario portal. In the event that you have not received this, but your tenant says they have filed, you may send an email to the landlord tenant board or call them. The email is ltb@ontario.ca with the rental unit address and ask if an application has been filed. The landlord tenant board can advise you if an application has been filed and what type of application that is. And you can also request that they send that to you.
Perfect. Thank you so much. So the last question that we previously received reads as follows. So out of curiosity, where can I view all the tenant application forms? Catherine, can you please answer that question?
Of course. You would find the tenant application forms the same place on the landlord-tenant board's website that you would actually find landlord forms. The website is tribunalsontario.ca/LTB/forms/.
Thank you so much. So whatever landlords go to the landlord and tenant board website to find landlord forms, they just have to scroll down and they'll see the forms for tenants section there. So now I'll pass it on to Silvana so she can start reading out the questions received during this presentation.
Okay, so we'll start off by Ashley. I'll direct it to Ashley. The first question, will the landlord receive tenant's evidence 7 days prior to the hearing? If yes, in what form? Example, by mail.
Yes, so a tenant is required to provide their evidence 7 days before the hearing. Typically, the form can take electronic is the most common method these days, which could mean an email, Just because a tenant has submitted it to the online landlord and tenant board portal does not mean that it has been served. Unless there is a consent by both parties, that evidence filed to the portal is the evidence that intends to be relied on at the hearing. It is not actually served. So the tenant should be serving it to you, whether that's via email or regular mail or in person, but it should be served. If it has not been, that would be an issue to raise as a preliminary, so before the hearing starts.
Thank you, Ashley. Okay, so the next question is for Catherine. Mediation is optional, and who's going to send this option to the tenant and the landlord?
Okay, so in most hearing blocks, there will be a mediator present on the day of the hearing. So if both yourself and your tenant agree to mediation, you would go in and, come up with some sort of solution with the aid of a mediator. You don't necessarily have to wait until the day of the hearing. If you and your tenant can, prior to the hearing, come up with some sort of, agreement that both parties, are happy with, on the day of the hearing, you can ask for what's called an order on consent. For a tenant application, maybe this would be, the tenant filed a T6 because, a leaky faucet in the bathroom, and you've since gone in and repaired, that faucet. And, for the inconvenience of the tenant, you've offered them a small sum of money. You would just go to the hearing and explain, everything's been remedied and this was the solution, and they will issue an order on consent.
Okay, next question, Ashley. What is considered serious error in an order?
So serious error in an order would be something that is outside of the law. So if the adjudicator either incorrectly interpreted the law or they made an error based on what the current law is, you would be able to review it for those reasons. If there's a serious error of fact, it would be similar. If the adjudicator heard the hearing, but there was a fact that was either not accounted for in the order or an incorrect fact that was accounted for, you would be able to review for that. But it has to be serious error in either the current laws or fact.
Thank you, Ashley. Next question, Catherine. Is the table of contents for evidence required? And if so, is it worth adding it even if the hearing is less than 7 days away?
It's certainly not a requirement. It is recommended. It's just going to make it easier, when you're in the hearing, to be able to identify, something is, tab A, this particular email. I would say that even though the 7 days of submitting evidence has passed, you could still submit a table of contents, because it's not going to be, new evidence, so to speak. It would just be, preparing and organizing their evidence.
Okay, thank you. Ashley, I work for a legal clinic and we only serve tenants. However, we do often come across self-represented landlords and tell them about the LSHC. What is the best way to refer? What are the services you provide, and do landlords have to pay for those services?
Okay.
I guess I'll answer that question since it's more about the services we provide at the Landlord Self-Help Center. So thank you for your question. And you can just give them our phone number or our website. We really try to motivate landlords to do the research on the website. We have tons of resources there. So that would be the perfect first point of contact to start. Otherwise, they can just contact us by phone. They can email and provide their phone number so we can call them back. They can request an appointment through Zoom. If they don't want to come in person, we have walk-in hours as well. They can walk in. And just a reminder, we're a community legal clinic funded by Legal Aid Ontario. So we provide services to the small scale landlords who qualified under the guidelines by LAO. We also have a membership program where any landlord that does not qualify as per LAO guidelines can receive our services, our summary legal advice services. So it's based on a case by case and whether or not they qualify.
Okay, so you can answer this one, Ashley.
Okay.
Okay. Okay, although the rent was increased twice in a year, the total amount still remained below the typical rent for similar units in the building. How can I defend this case in the hearing?
So you should definitely seek some independent legal advice. You can give our office a call for more specific legal advice on that matter. But general information would be that the guideline increase is only allowed to be done on the proper board appointed form, which would be an N1, every 12 months. But if you are looking for specific legal advice, definitely feel free to give us a call.
Okay, thank you. Catherine? Would a cleaning deposit be legal? Example, $200 deposit to be paid to a tenant if the apartment is left as clean as when they moved in. Otherwise, landlord uses that money to pay someone to clean a material and for materials.
So the only deposit that a landlord is legally allowed to obtain is last month's rent deposit. So a cleaning deposit would be considered a illegal deposit. And your tenant would arguably have up to 1 year after having collected that deposit to file a T1 application against you, and you would have to probably pay that $200 back.
Thank you, Catherine. Okay, Ashley, insurance company has called to do repairs on the property. They took a long time and didn't do the job adequately. Is it enough to show the board the efforts made towards fixing the issues?
Yeah, so landlord can definitely present that as a defense at a landlord and tenant board hearing. Ultimately, it would be up to the adjudicator whether that was reasonable and whether it resolved the issues or not. But it's definitely a good defense. So I would get any paperwork or relevant pictures prepared to present as evidence at hearing.
Thank you. Okay, next question, Catherine. Has the wait time for hearings decreased?
Actually, I'm happy to say that for all applications, we are seeing a lot shorter wait times for hearings. Just in general, we're seeing about 3 to 4 months for landlord applications. Tenant applications have always been scheduled longer. And I think the quickest I've heard recently was about 8 months. Again, we're not responsible for the landlord tenant board scheduling, so that can change at any point in time, but anecdotally from other calls, that's what we're seeing.
Okay, so the next question, Ashley, is a hearing open to the public? If yes, how can I some hearings to get familiar with how could I observe some hearings to get familiar with the format prior to my own hearing?
Yep. So hearings are generally open to the public. You can request hearing links from the landlord and tenant board directly. You can do that via their email, which is ltb@ontario.ca, and they will send you hearing links for any hearings that are going on. When you join, just make sure you're listed as observer and that you stay muted throughout the hearing with your video off.
Thank you. Okay, Catherine, if a tenant files an application to the landlord and tenant board and has accused in the forms are all wrong statement and not the fact, any consequences about that which offends the landlord or LTB?
Okay, I'm gonna try and understand this question and answer it appropriately. If I'm not getting the question right, feel free to give an office a call. I think what you're asking is if the tenant application is completely meritless and the tenant loses, what remedy there is for the landlord. The landlord tenant board, unlike other courts and tribunals, don't reward costs. So even if the tenant filed an application against the landlord and it was completely meritless and completely based on false accusations, in the event that the tenant isn't successful with anything, the landlord still has to have participated, defended the allegations, prepared their evidence, and they're not rewarded any sort of cost for their time or efforts in doing so.
Okay, thank you, Catherine. Okay, Ashley, what is the authority of the LTB for damages over $35,000? Does the LTB hear the case?
So you should definitely seek independent legal advice on that question as well. But generally, if they can only award up to the $35,000, and a landlord would have to abandon the excess, or a tenant. But either way, you should definitely seek legal advice if you have damages that are above the current landlord and tenant board threshold.
Okay, I think this is the same question as before. Although the rent was increased twice a year, the total amount still remained below the typical rent for similar units in the building. How can I defend this case at the hearing? I think we've already answered that one. Okay, so next question. So I think you didn't. Okay, what if a tenant brings up an issue that they never brought to your attention or that they said they didn't want changed? Catherine?
Yeah. Certainly, I mean, I guess it would really depend on what the specific situation was. A landlord has, some obligation to ensure that everything's in good state repair, regardless of if their tenants tell them or not tell them, or say that they don't care. Certainly, if your tenant filed an application against you over something you offered to fix and they declined it, I would make that a part of your defense at the hearing.
Okay. Okay, next question, Ashley. Can my tenant send all his evidence on the 8th day prior to the hearing, or he has to send it much earlier, more than 7 days?
So it has to be done at least 7 days before the hearing, but some people will send it early. The earlier, obviously, the better. It gives you more time to prepare, but the 7 days would be the maximum. If it's not sent within that 7-day period, again, you can raise that as a preliminary. So before the hearing starts, you can raise that you didn't receive the evidence until after that 7-day deadline, and the adjudicator will decide whether to allow it or not based on the reasons why it was submitted late.
Okay. So the next question, Catherine, what's the normal rent deposit interest rate tenant can charge?
Interest rates on last month's deposit are meant to be paid out annually at the same rate that the Ontario government has set as the increased amount. So if you're paying interest in 2024, it would be 2.5%.
Thank you, Catherine. Okay, Ashley, if a major repair needs to be completed in a unit, bathroom, for example, bathroom, would the landlord be responsible to cover the costs for those tenants to live somewhere else while the unit is repaired?
So generally, no. Generally, that would be a tenant insurance responsibility. But if you're looking for more specific advice, you can definitely give our office a call. But generally, it would go through tenant insurance if they have to stay in a hotel or Airbnb temporarily.
Okay. Next question, Catherine. Can you describe the process of obtaining the sheriff to follow through on an order the landlord and tenant board has issued for eviction if the tenant does not leave by that date?
Sorry, we would have to answer that question if the client or the person asking the question can call, because that's not about the webinar tenant applications, but we will be happy to answer that if you give us a call, please. So the next question is a bit of a general question, but what is a typical percentage for abatement of rent ordered by the board for a T6 maintenance application? I think it was Catherine.
Yeah. There is not really like a typical percentage or, like I guess, one way of calculating it. We can speculate what may be rewarded based on, case law we've reviewed. But that's really like a case by case basis. We would need a lot more information. It's also, depending what your tenant is seeking in the application for rent abatement. So that's another question where I'm going to kind of say, give our office a call and we will be happy to potentially provide you with more information on that question.
Okay, that's the end for our questions.
Thank you so much to Ashley, Catherine, and Sylvana for helping reading all the questions. And thank you so much for everyone that attended this webinar and all the questions asked. I hope that everyone learned something new today. And please join us on our next webinar. And we will be sending out the invitation and reminders. So yeah, thank you very much for watching. And if you have any questions, aside from the webinar, please give us a call and we'll be happy to answer all of them. Thank you.
I just want to say thank you everyone for watching. We always really enjoy putting these Lunch and Learn series on. We kindly ask that you take a moment to fill out our survey so we can know how to make the next one even better. If you'd like, there's a QR code on the slide that's currently on the screen. You can scan that now, or you will be receiving a link to our survey in the email that you registered for the Lunch and Learn series on. Thanks again, everybody.
Yeah, definitely. We will welcome all the feedback. So please fill out the survey.
Thank you so much for joining us.
Bye now.
Bye.